Good afternoon, everyone, and thank you for joining us for today's webinar, The State of Employment Law, Top Compliance Issues Facing Small Businesses. My name is Jamie Lizotte, and I'm the HR and Tax Compliance Solutions Manager here at ComplyRight, and I will be your host for today's webinar. So again, welcome everyone. And before we get started, I just want to go over some house rules. You can use the chat box on the left to ask any questions that you have. We will do our best to answer any technical questions that come in during the webinar, and then any other questions that are pertaining to the webinar topic will be held for the Q&A session at the end of the presentation. Just to let you know, audio from today's presentation will be coming through your speakers on your computer, so you want to make sure that your speakers are turned on and you have the volume turned up. And also, if you are signed in more than once, that will affect the way that you are hearing the webinar. So we ask that you please locate the duplicate login and close it out for a better experience. And lastly, just note that all attendees will receive a copy of the slides from today's webinar in an email that will follow within the next couple of days. So definitely keep an eye out for that email. And now to introduce our presenter for today's webinar, Ashley Kaplan, Senior In-House Employment Law Attorney for ComplyRight and Director over Legal Content and Labor Law Services. With more than 20 years' experience as labor and employment attorney, Ashley has successfully defended businesses of all sizes in federal and state court and government agency proceedings. She has also trained and counseled thousands of employers, and human resource professionals on how to manage HR compliance matters to avoid legal trouble. And here at ComplyRight, Ashley handles legal compliance, and she also oversees the teams responsible for researching all the posting laws, as well as developing compliance services for today's unique workforce. So welcome, Ashley.
Thank you, Jamie, and welcome everyone. Today, we're going to look at the current state of employment law, and specifically, we will take a look at the actual laws that are being passed on the state and local level, the trends that we've been watching that are already gaining momentum for 2019, and we'll cover what you need to know about them as an employer. As you'll see as we go through the material today, staying on top of employment law changes is becoming more and more complex and difficult to manage each year, because more and more laws are being passed on the state and local level, giving employees more protection in the workplace, especially on the local level. We are seeing so many new city and county ordinances coming out nowadays. We've seen this happen a lot with minimum wage laws, cities and counties passing their own minimum wage rates, and now we're also seeing this across the board in other areas of employment law when it comes to things like paid sick time, discrimination, and then the other topics that we'll dive into in a minute. And most experts agree that this trend will continue. While we don't expect much activity on the federal level, states and cities are picking up the pace and passing their own laws to address today's workplace issues. So in 2018, there were actually dozens of new employment laws enacted, actual laws that were passed on the state and local level. And we'll get into these in more detail today. And already in 2019, more than 1,000 state and local bills addressing workplace issues have already been introduced. So today I'll be focusing on the specific trends, the actual laws being passed on the state and local level. And as I go through the laws, I'm also going to cover a related trend affecting employee notification requirements. So as more and more employment laws are coming out, we're also seeing more notice requirements, laws that require you as the employer to notify your employees of their rights. And it's not just through mandatory labor law posters. In addition to posting requirements, employers are now faced with additional requirements where you have to personally distribute information to your employees about their rights. So it could be information sheets, notices, policies. You have to personally hand out information to your employees. And these handout requirements are really, really growing. So I'm going to try to highlight which laws have mandatory postings, which ones have mandatory handout requirements as we go through the presentation. And finally, I'll go over some important tips to help you navigate through all these changes and manage the inconsistencies between federal, state, and local law. Just tips that will help you, whether you're a small business with just a few employees or a larger company managing multiple locations across state lines. So this slide lists the areas where we've seen the most growth recently in terms of new state and local laws. And these are the trends that we're going to look at more closely today. We're going to cover minimum wage laws, various forms of legislation to promote equal pay, ban the box laws, paid sick time, some new trends emerging around predictive scheduling and opportunity to work, and I'll explain what those are, and of course the expanded protections against discrimination and harassment. And by the way, a lot of these areas listed here are already covered by federal law, and some of these federal laws have been on the books for decades without any changes. But the states and cities generally have authority to create their own versions of these laws as long as they're more generous to employees than under federal law. So that's what we're seeing, laws that give employees greater protections than available under federal law. And I'll highlight any relevant federal laws as we go through each of these topics today as well. Okay, quickly before we jump in, I wanted to conduct a poll, and we do have a really large audience, so we're going to do this really quickly. As I've mentioned, we've seen an increase in state and local employment law legislation over the past few years. When employment regulations roll back at the federal level, it's common, and past data suggests that rather than seeing complexity eased, businesses may instead see increased complexity with state and local legislative activity. But we want to hear from you. So please take a second and respond from your perspective. Over the past 2 years, do you think the complexity of managing employment law compliance at the state and local level has increased, decreased, or remained the same? Okay, that's even larger number than I expected. And sometimes when I talk to small business owners or even administrators in large businesses, I get mixed results on these. And I think it really depends a lot on what state you're in, where you're located. Are you in a location with a lot of local laws? And also if you manage multiple locations that have to deal with conflicting laws on the state and local level. And I'm sure a lot of it also depends on what resources you have in place for managing compliance. And every company is different, whether you're handling it in-house or outsourcing it to a compliance partner. In terms of how much of a burden these changing laws would have on you. Okay, let's start with a look at minimum wage laws. On the federal level, the minimum wage rate has not been increased since 2009. So it has remained at $7.25 an hour for years, for about 10 years. I did include a little note here that the minimum wage has increased more recently for federal contractors, but it's just certain federal contractors. And that rate was actually just increased most recently. It's been increased over the past several years, but it had its most recent increase in January of this year, January 2019, and it's now up to $10.60 an hour. And by the way, for covered federal contractors, there was a mandatory poster update when this increase went into effect. So you just need to make sure you're displaying the current version of the federal contractor minimum wage poster if you're covered by these laws as a federal contractor. You just want to make sure you're showing the 2019 rates. Federal contractors, by the way, actually have their own employee posting requirements, and they change all the time. I think we've already had 2 mandatory updates already in 2019. And it's really beyond the scope of what we're talking about today, but if you do want more information about federal contractor posting requirements, just let us know that using the chat feature, and we'll be sure to follow up with you. So back to minimum wage. The federal minimum wage for private employers is still $7.25 an hour, and there's no indication that this will go up anytime soon. And while there hasn't been any movement on a federal level, 29 states have increased their minimum wage rates above the federal level. And about half of the states now have minimum wage rates close to or above $10 an hour. So that's significantly higher than under federal law. Also, dozens of cities and counties have raised their minimum wage rates. And right now there are hundreds of cities and counties with pending laws that will impact local minimum wage in 2019 and 2020. So most of the states and cities with their own minimum wage rates also have these employee notification requirements, where you're required to notify your employees of their local rates either by posting mandatory posters or, as we'll see, some of these require both. In some cases, you have to pass out notices or information sheets about minimum wage. This last point here on the slide is important and something I get a lot of questions on. What do you do if your state has a higher minimum wage rate than federal law, or if your state and city have different minimum wage rates? And the answer is, and this is true with all employment laws when they conflict, you have to follow the law that is the most generous to your employees. So that would be, paying the highest minimum wage rate that applies to them. However, when it comes to the mandatory posters informing employees of their minimum wage rights, you actually have to hang all of the posters, even if the information conflicts. So if your city and state both have mandatory minimum wage posters, you have to hang the federal poster, the state poster, and your city poster. Unfortunately, I know it seems confusing to your employees, and I get it that the posters take up a lot of space on the walls, but this one is pretty black and white. This is what the law requires. Even though the information conflicts, all the postings have to be displayed. So this slide shows all the states with new minimum wage rates for 2019 and their effective dates. So there were 19 states that began the new year with higher minimum wages, where the rates went into effect on January 1st. 8 of those states automatically increased their rates based on the cost of living, where increases are made automatically based on the cost of living index. And those were Alaska, Florida, Minnesota, Montana, New Jersey, Ohio, South Dakota, and Vermont. And then the other 11 states increased their minimum wage rates due to previously approved legislation or just ballot initiatives. It wasn't tied to any kind of CPI or cost of living. Then we have the District of Columbia, Washington, D.C., and Oregon, and those are scheduled to have minimum wage increases on July 1st, 2019, and that's based on legislation that's already been passed. It will happen. And then also for the balance of 2019, Delaware has another increase scheduled for October, and Michigan lawmakers recently approved a 20-cent increase for 2019, and that one goes into effect in just a couple of days, March 29th, 2019. As I mentioned, a lot of states and cities have already introduced new legislation proposing to increase or further increase the minimum wage on top of these that we're already looking at. New Jersey, in New Jersey, Governor Phil Murphy just signed legislation into law last month to raise the state minimum wage through a series of gradual increases, where it's going to end up at $15 an hour by the year 2024. So the current minimum wage in New Jersey is $8.85 per hour, and that just went into effect in January 2019. And then under the new law, the minimum wage will increase to $10 an hour by July 1st of this year. By January 1st, 2020, it goes up to $11 an hour. And then thereafter, it increases a dollar an hour every year on January 1st until it reaches $15 an hour in 2024. And by the way, there is a mandatory New Jersey minimum wage poster that's required, and we're expecting the next mandatory update to that one to be released really soon in time for the July minimum wage increase. To the right on this chart, we've added a column to show which of these changes had mandatory poster updates. So as you can see, sometimes the minimum wage rates increase, but there isn't a mandatory poster change. And that is because either the state doesn't have a mandatory posting requirement for minimum wage, and that's the case in South Dakota and Washington. They do have higher minimum wages than under federal law. They just don't require employers to post information about it. Or sometimes we'll see it happen where there's not a new poster issued because the previous version of the poster already has the new wage rate listed, and the state agency just indicates that it's still compliant. They might put 2 years of wage increases on the same poster if it's already been established what the wages will be. Okay, so we've covered the state law changes for minimum wage, so let's move on to the local laws. At this point, more than 60 cities and counties have their own minimum wage rates that are higher than those set by the state or the federal government. And on this slide, we're showing some of the major cities with new minimum wage rates that just went into effect in January 2019. And all of the cities and counties listed here had mandatory poster updates to inform employees of the new wage rates. So you need to make sure for any of these locations that you have the correct posters up showing the rates for 2019. Some of these also had mandatory handout updates where you have to personally distribute information to your employees about the minimum wage. So just on this list, the cities that have mandatory handout requirements for minimum wage include Flagstaff, Belmont, Oakland, San Mateo, and Tacoma. But there are lots of other cities and counties that require mandatory handouts for minimum wage. They're just not on this list because they didn't have January 2019 increases. But some examples where the local requirements, where there are local requirements for minimum wage handouts include, a lot of them are in California. Like in California, you have to pass this information out to employees in Emeryville, Pasadena, Daly City, and Los Angeles County. And then there are also handouts required if you're in Chicago or Cook County, Illinois, and also Portland, Maine. By the way, I don't want to overwhelm anyone with all this information I'm giving about all the poster changes and the mandatory handouts, because I know it's a lot to keep up with, and there are just too many to list on these slides or to cover in a 1-hour presentation. There are literally hundreds of these posting and handout requirements nationwide. At the end of the presentation, though, our host is going to tell you about a couple of services that can help you stay on top of all these notice requirements, all the way down to the local level, city and county, where the service provides all the posters and all the handouts. All the regulations are monitored year-round for changes, and then they're updated automatically as changes occur. So there are options that can take the burden off of you when it comes to all these employee notification requirements. So one more point on this slide. This slide just highlights the increases for January 2019. We are expecting several more city minimum wage increases in July and at other times throughout the year for 2019 already. Portland, Maine is increasing their minimum wage to $11.11 effective July 1st. Several California cities are also increasing their minimum wage in July, including Los Angeles and San Francisco. The San Francisco minimum wage is actually increasing to $15.59 effective July 1st. So that makes San Francisco, by the way, the city with the most mandatory postings at a local level. There are now 10 postings required at the city level, and that's on top of the federal posters and the California state posters that also have to be displayed. For Los Angeles, the minimum wage rate is going up on July 1st, but the new rate depends on how many employees you have. So this is where I have seen some questions come in about, what if it matters if you're a small business or a large business and what that threshold is. But in this case, it does matter. Employers with 25 or fewer employees have to pay the new minimum wage rate of $13.25. If you have more than 25 employees, the new rate will be $14.25 an hour. And again, those changes will take effect July 1st, and there will be a mandatory poster update for Los Angeles covering these changes. Okay, our next trend is equal pay and some related laws intended to help close the wage gap between men and women. So equal pay laws have been on the books for decades, going all the way back to the Equal Pay Act of 1963. Equal pay is also part of Title VII of the Civil Rights Act of 1964, which prohibits discrimination in all aspects of employment, including compensation. Equal pay was also, on a federal level, equal pay was also a central focus of the Obama administration. In 2016, an executive order was issued. It was called Pay Secrecy for Federal Contractors, and it prohibits discrimination against employees who discuss their wages. And the purpose, of course, is to allow or promote open discussion among employees to help prevent unfair or unequal wages from going unchecked. So it's ultimately a measure, to prevent pay discrimination by protecting employees' rights to discuss their pay with each other. And that law, by the way, is another one that requires a mandatory poster for federal contractors. But that one's been in place for a couple years now. So while equal pay is already protected by federal law, state and local laws are broadening the scope of employee protections and in some ways giving these protections more tentacles. And they're doing this primarily with two kinds of laws, wage transparency laws and also salary history ban laws. So first let's talk about wage transparency laws. Wage transparency laws are similar to the the pay secrecy executive order that I just talked about that's in place for federal contractors. But on a state and local level, we're seeing these new laws introduced that would apply to all employers, not just federal contractors. And these laws, this proposed legislation, would prohibit employers from retaliating or discriminating in any manner against employees who disclose or otherwise discuss their wages with other workers. And the intent is the same. It's to promote more open communication so that if wage discrepancies exist, they're more likely to be exposed and not perpetuated. Right now, these laws are pending in several states, including Indiana, South Carolina, and West Virginia, as well as in several cities and counties across the country. And we're watching these bills carefully as they progress through the legislative process. As they become laws, we expect that most will also require a mandatory posting, just like the federal contractor posting. Salary history laws, salary history bans, are also gaining momentum. These are laws that restrict employers from asking job applicants about their salary histories. And the intent here is to end patterns of discrimination where your wage rates can carry over from job to job, and instead to base compensation decisions on the actual job position and the candidate's actual qualifications, not on history. So I've listed some states and cities here on this slide where private employers are no longer permitted to ask job applicants about their prior salaries. This list would be much longer, by the way, if we include salary history laws that apply to public sector employers. But this list here just applies to private non-government employers. Massachusetts was actually the first state to pass a salary history prohibition for private employers. California passed a similar salary history ban in 2017 that just went into effect last year, January 1st, 2018, it took effect. And then more recently, Hawaii and Connecticut had salary history bans that went into effect on January 1st, 2019. On a local level, similar laws have already been passed in New York City and San Francisco, and these also apply to private employers. Several counties in New York actually have laws that extend to private employers. Cincinnati, Ohio just passed a salary history ban earlier this month, and that one will go into effect next March 2020. And like I said, there are lots of other jurisdictions where these laws have been passed, but in that case, it's only for public sector government employers. There are lots and lots of those, but we're just keeping it here for private employers. There's also quite a bit of pending legislation on this right now, including laws that would apply to both private and public employers. Right now, there are salary history bills like this pending in Georgia, Illinois, New York, Pennsylvania, and West Virginia, as well as in several cities and counties. So it's important to know about these laws and to adjust your practices to get into compliance. The most obvious change that you're going to need to make will be to your job applications, making sure these kinds of inquiries are removed from your job applications for any locations with these salary history bans. You might also need to train your hiring managers, recruiters, and anyone conducting interviews, any managers or anyone participating in the interview process, to make sure they are aware not to ask candidates about salary history in interviews or really in any other pre-offer communication. So you want to update your applications and you want to train anyone involved in hiring. These equal pay laws in general also have mandatory posting requirements. For example, there are specific equal pay provisions required to be posted by employers in Georgia, Maryland, New Hampshire, and Pennsylvania. And when it comes to the salary history prohibition specifically, there's a mandatory poster addressing this new law required for San Francisco employers. And then in other jurisdictions, we're still waiting for posters to be released. Okay, so the next trend where we're seeing a lot of state and local activity has to do with ban the box laws. And these are sort of related to the salary history prohibitions, where the laws restrict what you can and cannot ask your job applicants in the hiring process. The term ban the box actually refers to the question, have you ever been convicted of a crime, that commonly appears on job applications. So ban the box means essentially that you cannot ask this question on your job applications or in any other pre-offer communications. That's just, I'm simplifying it because all the laws are a little bit different, but that's the gist of it. And this is a growing trend we're seeing in a lot of cities as well as on a state level, where the legislature is protecting individuals from being excluded from employment and other opportunities based on their criminal records. There are currently 33 states that have ban-the-box laws in place and more than 150 cities and counties. Then there are lots of other states and cities with pending legislation, proposed legislation, where proposed bills are moving their way through the legislative process. And pretty quickly, these we see a lot of movement on these. And like I said, each law is a little different in terms of what you can and cannot ask applicants. Some limit the kinds of questions you can ask, and some are a total ban on any kind of criminal history questions. And then also some of the laws prohibit you from asking about criminal history until after an interview, while others require you to wait until a conditional offer of employment has been made. So they are all a little different. This slide shows all the states that currently have some type of ban-the-box law. So you can see I've included an asterisk next to about 11 states here. And in those states, the law applies to both private and public sector employers. So it does extend to private employers in all the states where you see a little asterisk. In the rest of the states, it's just public employers for now. But there is some pending legislation that could change that. Usually we see the law where, originally it starts, when it's enacted, it applies only to public sector employers. And then as it evolves, it's amended to also cover private employers. So in fact, there's legislation pending right now in Colorado that the governor is expected to sign into law any day now that would make the ban-the-box law in Colorado apply to private employers. Right now it's just public. I've also included a little note here to indicate where there are mandatory ban-the-box posting requirements, and right now it's only Hawaii and Massachusetts. So the greater impact for now is when it comes to your job applications, removing these questions from your forms. But some of the pending legislation also includes posting requirements. So I did want to cover that, and we do expect to see more states making this a mandatory posting requirement as well. On a local level, there are now more than 150 cities and counties that have ban-the-box laws in place. On this slide, we've shown some of the major cities with ban-the-box laws. And as you can see from the little asterisks, these laws extend to private employers in several major cities. Philadelphia was actually the first major city to ban the box for both public and private employers in 2011. Kansas City added this requirement effective June 2018. Westchester County, New York is one of the most recent ones, and that law just went into effect in March 2019. Also, there are several cities with mandatory posting requirements, and this number keeps on growing as well. Right now, the ones with mandatory posting requirements around ban-the-box laws are Los Angeles, San Francisco, Philadelphia, and Seattle. And by the way, the posters typically refer to these laws as fair chance laws. So you wouldn't see salary history on your poster. You'll see them referred to as fair chance laws. Okay, the next big trend we're seeing take off on a state and local level is paid sick time. Under federal law, there is no requirement for private businesses to provide paid sick leave. There is the Family and Medical Leave Act, of course, but this only requires unpaid time off. Then there's the more recent paid sick leave executive order signed by former President Obama, but that one only applies to certain federal contractors. Again, it's an executive order and it only applies to certain federal contractors, not all employers. And by the way, the paid sick leave law for federal contractors also had a mandatory posting requirement that went into effect in 2017, and that is still a mandatory poster. There's also some legislation pending on a federal level regarding paid sick time, but most people would agree that anything pending right now on this topic is really up in the air, and it's too soon to speculate about the fate of these laws. A lot of you have probably heard of the paid leave bill currently pending in Congress, called the Family and Medical Insurance Leave Act, known as the Family Act. And that one would provide employees with up to 12 weeks of paid leave, not unpaid leave like the FMLA. It would be paid leave for a pregnancy, the birth or adoption of a child, recovery from a serious illness, or to care for a seriously ill family member. So it really mirrors the FMLA in a lot of ways, but it is paid leave. Congress also recently reintroduced the Healthy Families Act, and that's a bill that would allow employees to earn paid sick leave to use when they are ill, to care for a sick family member, to obtain preventive care, or to address the impacts of domestic violence, stalking, or sexual assault. There's also a bill pending on a federal level that would expand the Family and Medical Leave Act to add death of a child as a life event that would qualify for unpaid leave under the FMLA. And again, these are just bills at this point, and most would agree that they have a long way to go before becoming laws. So a lot of states and cities have stepped up, and they've been enacting their own paid sick leave laws that are more generous than what's available today under federal law. 11 states and Washington, D.C. currently have paid sick leave law requirements. And more than 15 cities and counties have their own versions of these laws. And these paid sick leave laws typically, again, they're all a little different, but they typically allow employees to earn paid sick days based on days or hours of work completed. So they accrue the time. And then the paid time off can typically be used to recover from illnesses, to seek medical care, in some cases to seek care for a sick family member or to take care of a family member. And then some of these laws would also include paid safe days. They're called safe days that provide earned leave for survivors of domestic violence, sexual assault, or stalking to seek services related to those kinds of incidents. So it's similar to the federal bill that's been introduced. This is a list of states with their own paid sick time laws. Connecticut was the first state to require private employers to provide paid sick leave to their employees, and that was enacted back in 2011. California became the second state when it enacted the Healthy Workplace, Healthy Families Act of 2014. New Jersey and Michigan were the latest states to join the list, with Michigan's law going into effect in just a couple of days. It becomes effective on March 29th, 2019. What is interesting about the New Jersey law is that, and you may have heard about this, it caused a lot of confusion, but the New Jersey state law actually preempted any city and county laws on paid leave. So it actually preempted 13 previously enacted local sick time laws in New Jersey. So in other words, what that means is cities and counties in New Jersey can no longer pass their own laws on earned sick leave. Everyone has to follow the state law on that topic. It's not necessarily the case for other city and local laws in New Jersey, but when it comes to paid sick leave, it has been preempted by the New Jersey state law. And this new paid sick law in New Jersey required New Jersey employers to post an updated labor law poster and also to distribute a written notice to employees about the law. The written handout actually had to be distributed to all existing employees by November 29th, 2018, so that deadline is already passed. And then thereafter, it has to be given to all new hires at the time of hire. So again, this is in addition to the posting requirement. So at this point, all new hires in New Jersey should be receiving this handout at the time of hire, and the poster should already be displayed where all employees can view it. In addition to the states listed here, there are several more that are considering similar legislation right now. Sick leave bills are pending right now in Hawaii, Maine, Minnesota, Pennsylvania, and Texas. And all of the states on this slide, by the way, have mandatory paid sick leave posting requirements, not just New Jersey. And when it comes to the mandatory handouts that have to be passed out to employees, those are required in New Jersey, like I said, and also Arizona, Massachusetts, and Washington. As I mentioned, more than 15 cities and counties also have paid sick time laws in place today, and I've listed some of the major ones here on this slide. As you can see, several are in California, and also almost every city or county listed on this slide does have a mandatory posting requirement to inform employees of their rights under these paid sick leave laws, and then a few also have the mandatory employee handout requirement. It's interesting with these mandatory handouts, some employment laws only require a poster, some only require a handout, and then some require both. So it's a completely separate requirement apart from the posters. and one that you definitely don't want to overlook, because there are fines and penalties and other legal liability for failing to comply, just like there are with the mandatory posters. These are, mandatory notification requirements. Okay, on the topic of employee handouts, we're just going to do one more quick poll. We're going to take a quick step back. We've been talking a lot about this new trend requiring more and more employee handouts, informing your workers of their rights under state and local laws. But we'd like to hear from you on this. How are you managing these new handout requirements? So please take a moment and respond. How does your business stay on top of state and local laws requiring mandatory employee handouts? Do you use in-house resources like in-house counsel or other internal compliance experts that you employ on your staff? Or do you depend on an outside resource like a law firm or HR consultant? Or is this something that you don't really have a dedicated resource for, whether it's internal or external? I'll go ahead to the results. Okay, this is interesting, and it's a pretty big split. And a lot of you relying on outside resources, which I have heard from a lot of businesses that they use lawyers and law firms to help them with this. So that's not a huge surprise. And again, at the end of the presentation, our host is going to be telling you about a new service that we've developed to help take care of all these employee handout requirements, federal, state, and local. And we were surprised. Our legal team did all the research for all these handouts, and we were surprised at how many there were. There are hundreds, and in one state alone, you can have up to 12 federal mandatory handout notifications to manage, and then up to 20 additional state ones. And then that doesn't even take into account all the local requirements on top of that. And it's interesting, most of the ones we've talked about today are required for all new hires. But some of these are only required, some of these handouts are only required in response to certain events, certain triggering events, like when an employee requests time off for an illness or a pregnancy, or when someone gets terminated. And it's really different for every law. And just like the posters, these change all the time, and the government doesn't notify businesses. But you are required by law to use the most up-to-date versions. So it can be daunting to stay on top of all the requirements on your own without a dedicated resource handling it for you. So like I said, I'm really not surprised with these results. And also, we will be happy to send you more information about the new employee handout service if you just request it in the chat box. We'll follow up with you on that. So another trend we are starting to see emerge is around scheduling laws. Inconsistent scheduling practices, such as on-call scheduling, especially in the retail and restaurant industries, have led some cities to pass these laws to provide more stability for employees. And these so-called predictable scheduling laws require employers to provide their employees with advance notice of their schedule, and in some cases to compensate employees for last-minute changes to those schedules. As you can imagine, these are highly controversial, but they are starting to pick up some pace, and we're seeing a lot more of these being proposed. At the state level, Oregon was the first state to adopt a law like this, and so far 5 cities, San Francisco, Emeryville, California, Philadelphia, New York City, and Seattle, have passed ordinances that require employers to give certain employees advance notice of their schedules. Philadelphia's ordinance was just signed in December 2018, and it goes into effect on January 1st, 2020. So there's still some time to prepare. And that new law for Philadelphia applies to employees in retail, hospitality, and the food service industries. It also has a mandatory posting requirement, by the way, and we're currently monitoring this one and waiting for it to be released. And other jurisdictions aren't far behind. There are similar predictive scheduling bills being considered right now as pending legislation on a statewide level in Arizona, Hawaii, Kentucky, and Washington State. Then we have these opportunity to work laws. And these laws basically require employers to offer additional work hours to existing part-time employees before you can hire new employees. The city of San Jose recently passed the San Jose Opportunity to Work Ordinance, and it requires businesses to keep records showing they offered the hours to part-time workers before hiring new employees. San Francisco has a similar ordinance called the Formula Retail Employee Rights Ordinance, but in that case it only applies to certain industries, not all San Francisco employers. And both of these laws, by the way, have mandatory posting requirements. Philadelphia's new ordinance that I just covered in terms of predictive scheduling also requires covered employers to offer available work shifts to existing employees before hiring new temp or permanent employees. So it also has an opportunity to work component. But again, that one for Philadelphia doesn't go into effect until 2020. Next is anti-discrimination, specifically as it relates to sexual orientation and gender identity. So under federal law, sexual orientation and gender identity are not specifically protected under workplace anti-discrimination laws. That's on a federal level. In 2015, a new executive order went into effect that does prohibit this kind of discrimination based on sexual orientation and gender identity, but this law only applies to federal contractors. And for the private sector, there was actually a landmark case in 2017 where the U.S. District Court for the Seventh Circuit recognized these protections under federal law, but that only applies in certain federal jurisdictions. It's limited. And then a year later, in 2018, the Second Circuit issued a similar ruling, but again, that's also just limited to a few regions. It's not recognized as federal law. But on a state and local level, more than 20 states and more than 200 cities and counties in the U.S. have passed their own laws protecting the LGBT community from workplace discrimination. And this is an area where we are seeing new bills introduced on a local level almost every week. They're just coming in constantly at the local level, cities and counties all over the country. One of the more recent development on a state level was in New York. In January of this year, of 2019, New York's governor signed the Gender Expression Non-Discrimination Act. And that new law amends the New York State Human Rights Law to expressly prohibit discrimination on the basis of gender identity and gender expression. And that's on a state level. And a lot of these laws, as I told you, as we go through, I'll mention postings and handouts. A lot of these laws do require mandatory postings and handouts. As far as the posting requirements, the states are all listed on the slide. These are all the states that have most mandatory posting requirements covering discrimination based on sexual orientation or gender identity. It actually adds up to 15 states and Washington, D.C. Another, this is related, harassment is a form of discrimination, but another big trend we've seen this year in employment law is tied to new sexual harassment laws. As states and cities are stepping in to strengthen prohibitions against sexual harassment in the workplace. And one of the main ways they're doing this is by requiring employers to conduct mandatory training to prevent sexual harassment. On a federal level, believe it or not, there are no federal laws expressly requiring employers to provide training to their employees or supervisors on harassment prevention. Now, the EEOC encourages all employers to provide harassment training, to provide anti-harassment training, and then several courts, including the United States Supreme Court, have ruled that employers cannot raise certain legal defenses in lawsuits if they don't provide adequate harassment training. But the law does not expressly require you to do it. It does not expressly require any kind of training or prevention on a federal level. Of course, in larger companies, we all know that it's gotten to the point where it's almost a no-brainer because of legal liability, where companies do conduct harassment training, and most people just assume that it is mandatory. But on a federal level, again, it's encouraged, it's important, it's a best practice, but it's not mandatory. So even though there aren't any mandatory federal laws on the books, states are increasingly passing laws that do have these requirements. Several states, most recently Delaware and New York, have passed laws aimed to prevent sexual harassment in the workplace. And in addition to training requirements, many of these new laws also have mandatory policy or employee handout requirements, written policy requirements, as well as mandatory posting requirements. So on this slide, we've listed the states and cities, the city of New York City, that currently have mandatory anti-harassment training laws in place for private employers. There are even more, like a lot of these laws, there are even more when we include the public sector, but this is the list just for private non-government employers. And the actual training requirements vary significantly from state to state, or city in the case of New York City. For example, the latest California law, as amended in 2018, requires employers with 5 or more employees to provide training to all supervisors and non-supervising employees, so all employees and supervisors. You have to provide at least 2 hours of training for all supervisors and 1 hour for non-supervisors, and the initial training has to be completed by January 1st, 2020. Going forward, the training has to be provided to all new hires and then repeated every 2 years. And it has to cover California law. It has to cover harassment based on gender identity, gender expression, and sexual orientation. The amended law for California also required employers to update their labor law posters and to distribute mandatory handouts to all employees. In Connecticut and Delaware, employers with 50 or more employees have to provide anti-harassment training. However, Connecticut employers are only required to provide training to supervisors, whereas Delaware employers have to train all employees and supervisors. In Delaware also, the Delaware law requires new employees to get training within their first year of hire, and then everyone after that has to be trained every 2 years. And that initial training, by the way, has to be done by January 1st, 2020. It's supposed to be done this calendar year. In addition to the training requirement, the new law requires Delaware employers with only 4 or more employees, these are smaller businesses in Delaware, to display a labor law poster and to distribute a sexual harassment notice or pamphlet to all new employees. So that handout requirement and posting requirement are, they apply even if you have fewer than 50 employees and you aren't required to do the training. In Maine requires employers with 15 or more employees to provide training to all employees, and it has to be done within the first year of employment. And then there's also a mandatory handout that's required for all employees. In New York, on the state level, all employers have to provide sexual harassment training annually to all employees. And the initial training has to be completed by October 9th, 2019. Employers in New York also have a posting requirement and a mandatory handout requirement. On the local level, I mentioned New York City. Under a new law, New York City has its own training requirements. And that law applies to employers with 15 or more employees, and it requires annual training for all employees, including managers, supervisors, and non-supervisory employees. That law takes effect on April 1st, 2019, and employees must be trained by April 1st, 2020. So there's a year to get the initial training completed. And this law has both a posting requirement and a mandatory handout requirement. The poster, by the way, has to be displayed in English and Spanish for all covered employers. It doesn't matter if you have all English-speaking employees. It has to be displayed in both languages. And the handout has to be given to all employees at the time of hire. It's a new hire handout. And we expect to see more cities and counties passing their own anti-harassment laws, especially in cities that are in states that don't have their own specific training requirements. That's where we're seeing most of the proposed legislation. We're also starting to see some industry-specific requirements, like a new law going into effect this year in Washington, D.C. that will require harassment training for employers with tipped employees. So that's sort of an industry-specific requirement. And by the way, the content of the training also varies from state to state or for a particular city. Each state or city with mandatory training has its own requirements as to what the training must cover. You have to cover the laws of that state or city. So to summarize, for employee notifications, written policies or handouts addressing harassment prevention are now required in California, Delaware, Maine, Massachusetts, New York, Rhode Island, Vermont, and New York City. As far as labor law posters, harassment is covered in almost every state's fair employment posters, because it's a form of discrimination, but we have seen some updates lately that are tied more specifically to these new laws around preventing sexual harassment. So just in the past year, we've seen mandatory poster updates addressing anti-harassment laws for California, Delaware, Illinois, New York, Vermont, and then of course there's also that city poster I mentioned from New York City. Okay, so in closing, I wanted to go over a few more tips, kind of tying in everything that we've talked about, that will help you manage through all these changes and the flood of state and local activity that we're seeing. First, conduct an internal audit of your employment practices to ensure compliance with federal, state, and local laws. And the best way to do this would be with legal counsel who's familiar with all the intricacies of your state, city, and county employment laws, as well as any industry-specific requirements you might have, especially if you're in food service industry, retail, financial, healthcare, or if you are a public sector government entity. There are all sorts of special requirements. But at the very least, make sure you're aware of the laws from your state and local authorities, especially on these topics that we covered today that are changing so quickly. The local city and county laws are usually the most restrictive, so you can start there and then brush up on current state and federal requirements from there. Number two, when you come across any laws that conflict, make sure you follow each law's provisions that are the most generous to the employee. We've talked about this throughout the presentation, but it's so important. So for example, you would follow the paid sick leave law with the longest period of leave if your state and city have two different versions. And remember, states have authority to pass laws that are more generous than under federal law, and cities have authority to pass laws that are more generous than under state law. So keep that in mind when you're reviewing these and deciding which laws you have to follow. Next, address any areas that require policy adjustments, such as adjusting your wage rates to meet local minimum wage rates, or updating your job applications to remove criminal questions or salary history questions. Or it might mean editing your written policies, your manual or your handbook policies, to make sure you're providing the right amount of paid time off if there's minimum paid time off requirements. Or in your policies, make sure that you're covering these expanded anti-discrimination protections. If you're in a location where additional characteristics are protected, you want to add that to your EEO policies and your anti-harassment policies. And just always remember, you have to offer the terms that are the most beneficial to your employees if you have state or local laws in place that conflict with federal law. Also, don't forget on this point, don't forget to look at your harassment training, your practices around training, and make sure you're conducting any mandatory training and that you're using the correct training content for your city or your state if you're in one of those areas that have mandatory training requirements. Otherwise, you just need to train under federal law and follow federal requirements. In terms of talk about federal prohibitions against harassment, even if it's not required. You should go ahead and train on the federal anti-harassment laws. You also might need to update other aspects of your hiring practices. I talked about the job applications, but you also might need to look at other parts of your hiring practices to eliminate those prohibited questions from the interview process, as well as other pre-hire inquiries or communications. Just get anything about criminal or salary out of anything pre-hire if you're in one of those states or cities where you can't ask those questions. Number four is a tough one. If you have multiple locations that fall under different laws, sometimes you have to make a choice. You can stick to the letter of the law and have different policies in place for each jurisdiction, like different leave policies depending on where the employees work. Or you can adopt a consistent policy across the board for everyone. But of course, it would have to be compliant with the law that is the most generous to your employees. So in other words, you would be going above and beyond the law's requirements, being overly generous in locations where you don't have to. And this really depends on a lot of factors, whether this is a good idea for your business. You would look at your size, your resources, your overall culture toward compliance. Obviously it can be costly to offer benefits that you're not required to offer, but then there's also a benefit to simplicity and uniformity as well. I've worked with a lot of clients that operate in multiple states, and sometimes they'll have one unique handbook just for California because the laws are so restrictive, and then they were able to come up with another version that works in every other state, just based on out of the remaining states, which provisions are the most restrictive for their employees, and they do it that way. For number 5, unfortunately, you don't have the luxury of making a choice here. This is something I mentioned earlier in the presentation. The law requires you to display the postings for the actual locations where you do business, and that includes federal, state, city, and county, even if the information on the posters conflict. And finally, the best way to stay on top of all these laws and changes when it comes to employee notification requirements is to assign a dedicated internal resource to research and monitor all the laws and updates, or to outsource this task to a partner that specializes in this, a partner that specializes in posting and employee handout compliance, which I would especially recommend if you have locations in more than one city or county. There's just too much to keep on top of, and once you find all the required postings and handout requirements after you do that research, they change so quickly that it really becomes almost a full-time job to get it right and stay on top of it and keep it compliant. And of course, you want to make sure to choose a partner with a dedicated legal team and one that covers all of your city and county needs, the local requirements, because that's really one of the most difficult parts to manage. And as we've seen today, it's only getting more complicated as we go on that local level. Okay, well, that wraps it up. I hope you found this presentation to be helpful and informative. I know we went over a lot of information, but there's a lot to share when it comes to your obligations today as an employer, trying to keep on top of all these developments. I think we are going to have some time for some Q&A, but in the meantime, if you have any questions or would like additional information about Poster Guard or any of the compliance issues that I've talked about today, please feel free to contact our compliance specialist, Peter Frey, at 954-970-5702, or you can reach Peter by email at pfrey@hrdirect.com. Thanks again for attending today's presentation. I hope you have a wonderful afternoon, and I'm going to turn it back over to our host.
All right. Well, thank you, Ashley, and most definitely thank you for sharing all of that important information. As you said, there's a lot for the businesses to stay on top of, so it's much needed information that you shared with them. And we did receive a lot of very good questions. We do only have a few minutes, so instead of going to a lot of detail about the Poster Guard service, I just want to very quickly highlight Poster Guard Compliance Protection is a complete labor law posting compliance solution that is available, and it covers all federal, state, and local posting requirements, including every local jurisdiction in the United States, every city and county. So if you would like more information on this service, again, as Ashley mentioned, you can contact Peter Frey, who's the compliance specialist, at the phone number that's on the slide, or you can email him directly at his email as well. So let's go ahead, and I did choose a few questions that came in multiple times. So the first question I want to jump into is, we are too small to be covered by the Federal Family and Medical Leave Act. Can we just create our own leave policy similar to the FMLA and use it for all our employees in multiple different states?
Okay, well, it depends. I know everyone jokes that lawyers always answer with it depends. But if you are in a state and a city, if we're talking about a state and a city that don't have any relevant laws on paid or unpaid sick time or medical leave, then you are free to develop your own policies. However, you want to be, I see you mentioned that, to use it in multiple different states. So you would need to look at the laws for all of your locations and make sure there aren't any requirements, state or local requirements that would kick in. Now today we talked about paid sick leave, so you obviously need to look for that. But there are also a lot of laws out there that cover smaller employers not covered by the FMLA that require unpaid leave, where you have to give guaranteed time off, job-protected time off, even though it's unpaid. So you need to look at those kinds of laws too. And then you just have to make that decision that I was just talking about. If you want to use the same policy in multiple different states, you either have to come up with one policy that's the most restrictive, that follows the most restrictive laws, the ones that are the most beneficial to your employees, and use that policy, or you can develop different ones for different states if you don't want to live with the same terms for all your employees when you're not required to.
All right. Well, thank you for answering that question. And unfortunately, that is all the time that we have available as we've hit our hour mark. But again, thank you, Ashley, for answering that question. But before we sign off again, I want to thank all the attendees for joining us today. Definitely thank Ashley, our presenter, for sharing that multitude of information that we had. That was definitely a lot of valuable information, and I hope everybody was able to take away something from this. You will receive an email as a reminder within the next couple of days containing today's presentation slides. So again, keep an eye out for that email. And don't forget to look out for our next webinar in April. And as always, until next time, happy complying. Have a great afternoon.